For Creamer Media's Polity, I'm Shannon. I'm with Daniella Kafouris to discuss the proposed amendments to the ECT Act. Can you provide a brief background of the Electronic Communications and Transactions Act and what the main issues that the proposed amendments seek to address?
Well, of course, basically the Electronic Communications and Transactions Act, we can just shorten it to the ECT Act because it's a lot easier, came into being in 2002. And it was brought about in order to facilitate electronic transactions. Essentially, one of the greater things that it did was confirm that anything in data format was still considered in writing from a legal perspective. So it brought validity to things in electronic format. Over and above that, it brought about, the naming of our cyber crimes and what would be considered as a cyber crime. It explained how we'd facilitate electronic transactions, even from a direct marketing perspective, with regards to unsolicited commercial communications. So it brought about a lot to bridge a digital divide in South Africa, but let's put it this way, it was sufficient for 2002, which is why a lot of the new amendments have come out, well, not yet come out, the proposed amendments are being discussed as of last year, in order to bring it up to standard from what it's been the past 10 years.
What is the process by which these proposed amendments be passed into law? Is there still an opportunity for the public and industry to comment?
No, not anymore. The public comment closed on the 7th of December. So after that, there is no more public comment. What is going to happen now is it's going to be taken through to the parliamentary committees, and from there, National Assembly, National Council of Provinces, and so forth to see. So we're going to follow the normal course of events for a bill.
Are the proposed amendments and South Africa's electronic communications law in general in line with international laws?
Well, that is the purpose that we're actually trying to achieve with these regulations, these proposed amendments, purely because when you look at the EU and how they've moved in the technology law sector, and when we talk technology law, we're including data privacy law as well. We need to align ourselves to that. Having started with the CPA and now moving towards the Protection of Personal Information Bill, which is hopefully going to be passed soon, we needed to bring the ECT Act up to the same sort of level. Being able to facilitate the international transactions and looking adequate on an international playing field is extremely important for us. So these are definitely, between the ECT Act as well as the POPI, Protection of Personal Information Bill, coming through, these are two very significant pieces of legislation for South Africa.
Could these proposed amendments affect social media networks in any way? If so, how?
Absolutely. Well, if you look at the provisions, first of all, let's look at POPI. Okay, POPI uses an opt-in mechanism, which means you would need consent to do direct marketing and so forth. Now, what they've done with the proposed amendments in the ECT Act, they've said, right, well, we're going to align it with POPI. Now, all these years, it's been opt-out. So where you'd get an SMS, you could reply stop and it would cost you R2, or click a link in an email to unsubscribe, and that was sufficient. So you could receive direct marketing communications, and whether you wanted them or not, you'd still receive them, and if you didn't want to receive them any longer, you'd have to opt out. What we're moving towards now is a version of consent, saying, no, I want to tell you if I want to receive these sorts of communications. And this could pose a bit of a problem for a lot of direct marketers. But what is actually happening is the best way to approach things like this is to move onto social media. And the reason for that is because social media is inherently opt-in. I have to like your Facebook page if I want to hear what you're telling me about. Yeah. I have to follow you on Twitter if I want to hear about your marketing, about what's happening in your organization, or even individually as people. I tell you that I want to hear from you. And with social media having this buzz, and it's the perfect time for organizations to build strategies around social media, because it is a more compliant way of doing things. Obviously, within those strategies, it has to be done in the right way, so you don't contravene any other laws and so forth. And obviously, privacy is a very important aspect of it, but it is the best time to start looking at those types of strategies.
What could the amendments mean for direct marketers?
Well, essentially, for a lot of direct marketers that have been purchasing databases and marketing to people that didn't know they wanted to even be marketed to, you know. All these sorts of things will change with the ECT Act and with Poppy. Purely from a direct marketing perspective, we will need to get consents. And so, you know, they'll have to think of creative ways of getting those consents, because purely going and asking a person, can I market to you, you might not always be met with the desired answer that you want, after, you know, what South Africans have gone through in the marketing space as well. But on the other hand, you know, the marketers do need to survive. So there are compliant ways of doing things within the legislation, but everyone is going to have to be a lot smarter in the way they approach it.
How do the amendments relate to the Protection of Personal Information Bill and the Consumer Protection Act?
Well, essentially, you know, the whole reason most of these amendments came into play, because there are a lot of other amendments that speak to cryptography service providers and other sorts of things. But from the consumer protection side, the consumer protection provisions in the ECT Act always stood where the CPA couldn't apply to those certain things for electronic transactions, e-commerce, those sorts of things, okay? So they will keep those, and those will stand because it keeps it in line with the CPA. In the event that CPA ever changes and they start including the online version of what they want to achieve for consumer protection, then those parts in the ECT Act might fall away. But as it stands now, those will stay. From the perspective of the Protection of Personal Information Bill, what has happened is they've aligned, for instance, the definition of personal information to be the same as Poppy. The direct marketing provisions have been aligned to be the same as Poppy. But the whole idea is, once Poppy does come into play, because it will govern how you process personal information in your organization, it will replace those in any case. But it's literally whoever gets to the finish line first between ECT and Poppy.
Thank you for your time. That was Daniella Kafouris discussing the proposed amendments to the ECT Act.